The broadcast is now starting. All attendees are in listen-only mode.
Yes, hello everyone. Good afternoon. I hope everyone can hear me clearly. I welcome you all on behalf of GHV Accelerator and Just Contractors. GHV Accelerator and Your Story have come together to begin a series of webinars for helping startups and entrepreneurs get into Series A funding. That is our prime aim. I shall be having with me two speakers, Anurag and Payal. I shall be introducing both of them to you soon. They will help you understand why we are here in the first place, is because we're looking at helping you with um, most of these entrepreneurs and startups. What are the legal aspects that you need to know while you are raising Series A? So let me introduce Anurag first. Anurag is the executive director of GHV Accelerator. He's also the ex co-founder of and MD of Megstrat Consulting. With over 10 years of experience, some of his key expertise areas include business plan development and appraisal, brand promotion and marketing, investment research, business research, market research, strategy formulation, goal setting, and leadership development. And Payal from Just Contractors has had the opportunity of working on some exciting projects, including foreign direct investment, acquisitions of listed and unlisted companies, marketing arrangements for a new product in the wireless mobile telephony space, real estate acquisitions, advising overseas entities on antitrust and competition laws, sale of developments, rights on land, etc., etc. They would be helping you, both of them, understand what are the legal issues that startups usually face and what are the things they need to take care of when they're looking at raising Series A. What is it that the investors would ideally want to see when they are looking to invest in your company? Over to Anurag and to Payal.
Good afternoon, everyone. I'm Anurag, and thanks to the introduction from Ritika. So, as Ritika rightly mentioned, the objective of the webinar today is to help entrepreneurs and startups understand the significance of having the right legal processes in place in order to make sure that there are no hiccups towards the end while cracking a deal, between a startup and a investor. So having said that, we have a small discussion platform where I will be raising certain questions as an investor's perspective, and Payal, with her expertise, she would be the best person who would be able to address these queries. So as a format, you would be able to understand the investor's perspective as to what are the areas where we look for, proper compliance and, things to be in order, and where these things we feel are missing in a lot of startups. And Payal can help us in understanding how to resolve these, problems. So I hope you're able to see a presentation on the screen. Now, if you go to the first slide, essentially we are an accelerator with a difference. Definitely for more information, I would request you to look at our website. On the problems that we face on the legal side, let me take you to the next slide. Yeah. Incorporation is a big concern when with a lot of startups. We have been able to review, and biggest concern that I've seen, a lot of them start in a very unorganized way. Understandably, when the ideation stage is graduated, the first step is to formulate any formal entity just to make sure that they can carry out the business. But what really happens is that everything is scattered if it's not organized, and when the documents are requested by the investors, since the inception of the company, the data does not tie up with the establishment date, and that becomes a little bit of a problem for us. So that's where I think I would really request Payal to help us out in understanding the investor's dilemma and trying to resolve it in terms of how this incorporation can be done in the most conducive fashion, so that the investor gets the right information and is able to get excited about a startup from compliance's perspective as well, and is not worried towards the end when once they have taken the decision that okay, this is a good startup, we would like to invest in this, and they should not fall back at the time of the due diligence stage, because that's where legal compliance comes in. So Payal, over to you. I would request you to share your insights on this.
Yeah, so just for the benefit of everybody, typically when startups start out, they would start out as proprietorships, and that's quite rightly so, because the compliances are the least, and it's the easiest to begin a business either as a proprietorship or a couple of people to get together and form a partnership under the 1940 Act. Unfortunately, neither of those structures work for an investor. So if I were an investor, I'd be looking for to be able to make a safe investment, and that can typically now happen with two structures. Earlier it was only one, which was a company, but now they can be two structures. So you can either have a company or an LLP. But in order to, for the benefit of those startups who are here, I think it will be beneficial for you to hear what is the difference between a company and an LLP. So in a company, typically what happens is it's an incorporation where shareholders get shares in a company. So it's a separate legal entity from the shareholder, and what a shareholder gets are shares, as opposed to a partnership pie in a LLP. So typically in an investment scenario, an investor would get an X amount of shares. So if, let's say, there are 100 shares in a company, depending on the equity an investor is bringing in, they would get in, if it's a minority stake, so typically it could be about 25%. If it's majority, it would be 51%. But in a partnership, it would be a piece of that pie, actually, the separate legal entity, you're getting a part of the partnership. Just to take you through a couple of differences and similarities between companies and LLPs, so that will enable you and perhaps your investor to decide which is the best investment vehicle for you. I'll just take you through a couple of differences and similarities that we've put together for you through these slides. So the first one I've already told you, investor gets shares as opposed to a percentage of the partnership between a company and an LLP. The other thing I'm just going to take a minute to talk about is FDI. Anurag, I can't see the, yeah. So FDI is foreign direct investment. If an investor is coming in from outside, making an investment into your business, they have to at the outset check whether that particular business is FDI compliant or not. And that typically comes from the consolidated FDI policy. So if you have an entity which is a company, then that FDI will be in accordance with the sectoral caps permitted by the consolidated FDI policy. However, if you have an LLP, you have to be careful, because FDI will be only permitted where under the consolidated FDI policy, 100% FDI is permitted in that sector. So for example, if the sectoral cap permitted only 51% FDI and you were set up like an LLP, then you couldn't get foreign direct investment. So I hope everybody is clear about this, but if not, then we'll just put that down as a question and we'll talk about it more when we do the Q&A, when we open up the webinar to Q&A. Anurag, if I can just request you to flip over to the next slide.
Sure, Payal. Let me just do that. Yeah.
So if you're set up as a company, you will be governed by the Companies Act 1956, but now it's the 2013. If you haven't already incorporated yourself, it'll be the 2013 Act or the rules that are made under the Act. LLPs are governed by the LLP Act 2008 and the various rules that are made under it. Each director in a company requires a DIN number, as opposed to DPIN number if you are a designated partner in a LLP. So the difference really is that companies are run through a structure of, through a board. The board is constituted of directors, which could be internally appointed, or which hold-time directors, or externally appointed, as opposed to an LLP, which is typically run through its designated partners. So there is actually, under the LLP Act, a separate designation for partners who run the LLP. So So designated partners would be akin to management in a company. Now, in terms of minimum number, you would have a company would require minimum of 2 shareholders in a private limited company and a maximum of 50. For a public limited company, the minimum would be 7, and there's no upper limit on the number of shareholders. Just by way of a point, you can now also have a single member company under the 2013 Act, but it doesn't help you because you actually need investment to come in. So a single member, I'm not talking too much about it because this from an investment vehicle doesn't help you. An LLP requires a minimum of 2 partners. Anurag, can we flip to the next slide?
Sure. Yeah.
Now, in terms of directors, again, in a private limited company, you would require 2 directors and 3 in case of a public limited company, and in an LLP, at least 2 designated partners. Now, in case of death or removal of a director, actually nothing really happens to a company. The MOA and the memorandum and the articles of association of a company, which are really your incorporation documents, or your driving documents, your Bible, so to speak. Nothing really in that changes when directors are appointed or their resignation is sought, or a shareholder exits, or a new shareholder comes in. But this has a huge bearing on your LLP agreement, which is the Bible for an LLP, because the induction, death, resignation, removal of directors can actually, in certain instances, if your LLP agreement doesn't provide for it, can actually result in the reconstitution of that LLP, requiring you to get into an absolutely new document, which would require to be filed afresh with the registrar. So I think we've covered all of the points on this page. Anurag, do you have any questions on now? Okay, so the last one is the similarities between LLPs and company. Both require registrations, albeit it'll be different because one will be under the Companies Act 2013 now, and the other under the LLP Act 2008. Both are creations of the law. Both have perpetual succession. Because these are entities which are separate from partners and shareholders, they can actually purchase both movable and immovable property in their own names, as opposed to a proprietorship, which is just an extension of that individual. Both an LLP as well as a company can be sued and can sue. And this is as opposed to a partnership under the 1940 Act, which, unless it was registered, could not sue. It could be sued, but it could not sue. And now digital signatures are a prerequisite for e-filing in the case of a director or a designated partner in an LLP. So that really brings me to an end of the first part of what I wanted to speak, which was the differences and the similarities between a company and an LLP. Anurag, over
Thanks,
to you. Yeah.
Yes, I think there's some delay on my side. I'm hearing you a little late, probably. Anyhow, now on the second subject that I wanted to understand, on the intellectual property side, there have been times when startups we have discussed with startups, and there's some of them are creating a frugal innovation, some of them are creating a concept, some of them are creating a technology. Now, the gray area for them is their technology patentable? That's one. Second, um, some component of the technology is available or rather manufactured by someone else, and they take the raw material in some finished form from another entity, and that becomes kind of a product that they are buying. So they have a question in terms of whether the product is patentable. That's where I see a gray area, because the whole technology is not theirs, but they're using a component from someone else, and so these are some gray areas where they are not very clear, and as investors it becomes very difficult for us to assess the long-term competitive advantage that they may be that they may not derive, because they don't have a proper IP in place. So if you can throw some light on that, that will be very helpful.
Okay, Anurag, what you touched upon is an extremely important aspect with regard to investment, particularly. Now, one of the big challenges for any small organization is the intellectual property, like you've correctly said, because there are so many nuances involved. Oftentimes, startups, because of because of the lack of knowledge in that area, can actually end up losing a huge value that can ordinarily be derived from bigger organizations.
Okay.
And in fact, I'm just going to deviate a little bit, Anurag. And if you're going to be doing a series on startups, one of the presentations you should be looking at is a full-fledged presentation on intellectual property, because the area is so vast and there can be so much value derived from intellectual property that this would, I think, really help the audience. Now, just
Sure.
in very brief, typically organizations, if the turnover is X, an intellectual property, if correctly Cola, the one with the Spencerian script, is valued at approximately 80 or 84 million dollars. So that's, if you were to just sell the company today, sans its trademark alone, and that if somebody just bought Coca-Cola on its own, that's the kind of value that Mark is capable of deriving. But having said this, intellectual property is of various types, and the identification, and I'm again using those words, the identification, the protection, the strategy around which intellectual property are we going to protect, and what is the kind of value that we are going to derive out of it, is really where a company's, how would I put it, I think a great deal of thought needs to go into that. So typically IP is, they are trademarks. Trademarks are, for instance, Coca-Cola or Google, by the very name, that creates a connection in the course of trade between the consumer and the proprietor of that mark. So when you're looking at the mark Coca-Cola, or you're looking at Google, you know which company owns this product, and which is why you buy that product. Like a Levi's jeans, you're buying it because that trademark conveys a certain sense of quality. Copyright, on the other hand, is, for example, literary or a dramatic work. So a book or a play, a song, a musical, those would typically be copyrights. Also softwares, so companies that are looking at getting into IT or are in the IT space, copyrights are extremely important to them, because their software is protectable through a copyright. A patent is the highest form of protection, and that is typically in an engineering in a product which has, for example, Tetra Pak, which is extremely novel and new, that would be protectable by a patent, or a mobile phone which has great technology, innovative technology. Designs are a lower form of patterns, but those are something that is visually attractive to the eye. And lastly, things that are incapable of a patent protection can be protected through a trade secret. For example, the 7X formula of Coke is protected through a trade secret. But a trade secret loses its significance if that secret is brought out into the open. So all that a person who has a trade secret would be able to seek as damages, but can't protect the trade secret even if it came out into the open from an illegal act.
Okay.
So, so these are the various types of intellectual property. They serve a different function. They have to be protected differently, and a different value has to be derived. So great amount of thought needs to go into protection of this IP, because a lot of the times it can be very, very expensive to protect.
Yeah.
So once closely considered, budgeted, you can then get your investor to say, listen, this is the amount of money that I require, and partly because a lot of it requires IP protection.
Right. Makes sense completely. So, so as an investor, correct me if I'm wrong. So if I'm looking at a startup which does have some level of intellectual property applied for, let's say they've applied for a patent, and they say that the patent has been filed for, and it may take up to 1.5 more years to come, and till that time, is my interest protected? In
Yes.
terms of as an investor and as a startup, are they protected? Can someone else file a similar patent or something?
So again, I'm stressing that patents are very different from designs, copyrights, and trademarks.
Right.
And a patent is, when filed, I assume would have gone through a process which is a search process, which is very extensive. And if only 1.5 years are left to the patent, it's probably in an extremely extended state. So while, yes, theoretically it's possible for another person to file a patent, but because of the fact that somebody made the investment to file a patent, which is very, very expensive, the
Right.
fact that they filed and it's gone through to 3/4 of the time of the patent being achieved, it would be a really great investment to make, subject to you doing your due diligence in terms of the search and so on and so forth. But
Okay.
remember one thing, that once the patent is granted, the protection of it comes retrospectively from the date of the application. So for instance, if I have a patent application which is pending and somebody else started to use that product in the market, then once
Yeah.
the patent goes through to registration and I sue the person would
Right.
not only have to stop making what they did, but also give me damages for the amount. So, generally on patents, companies don't usually mess with that sort of thing. Because we saw that in that whole Apple comes Samsung recently, where
Right.
Samsung lost, and you remember the amount of damages that they had to pay, and also pull the product off the market.
Exactly. So being in the startup space, I think both from the possibility of potential that the product has, and also from the budgeting perspective, everything becomes very important from the legal viewpoint to have a patent in place. Not just a patent, maybe whichever intellectual property is suitable for that particular model. So thanks,
Absolutely.
Payal. I think really helpful. I would be happy to take questions, towards the end. In the last Q&A, I'll move to the next challenge that we believe exists in the market, which is compliances with the regulators. Now the problem that I have experienced as well is that as a startup we are not very conscious about compliances, because it's a very casual attitude to start with, because we are, as startups, they're expected to be more focused on their product or their technology, trying to get more orders, so they forget about the compliance part. Each and every, so as an example, recording all the financial transactions religiously, taking care of all the petty expenses. What I've seen is, whenever there's any small transaction happening, the entrepreneur does not really treat the company's expenses and his own expenses separately, because he's close to the company and he says, I can do it for the company, that's fine. But when the financials are compiled, those expenses are not recorded. Just as a small example, and as this happens, this keeps growing with time, and let's say 1 year or 2 years later, you realize that the numbers are completely incorrect because of not recording these transactions. So that's one example where I feel that startups have to be very, very religious from the day one. But if you can throw more light on how they can make sure that these compliances don't happen, and this is just one example, there would be several other areas where they need to make sure that this compliance is done from day one. If you can throw some light on that, that would be very, very helpful.
Anurag, I can't agree with you more, because, and I'm also an entrepreneur in that sense, because currently, the proprietorship and the individual is the same. So there isn't so much of a demarcation in terms of financials between yourself and the proprietorship. But that financial as well as legal compliance discipline has to be maintained from day one. Just by way of an example, we've seen what's happened with Uber. And particularly for startups in the manufacturing space, you have to be extremely careful. And I, typically put the legal compliances into 4 buckets. The first bucket is on the factories and the labor space, and also the ones in the services sector. For them, the Factories Act will be replaced by something known as the Shops and Establishment Act, which thankfully in Delhi, I must say, under Section 5 has been held in abeyance for the past couple of years. But all of the compliances under the Shops and Establishment Act are still required to be maintained. Then the second bucket would be on the environmental legislation space, and this is very key for the ones that are in the manufacturing space. So you would have your compliances for air, water, noise, hazardous waste, liquid waste. You would also require compliances in the space of the particular industry that you're in. For example, if you were in the space making insecticides, then the Insecticides Act would apply. If you were in the space where you were making drugs or a cosmetic, then the Drugs and Cosmetics Act would apply to you. So that particular space that you're in, what law applies to you, those compliances need to be met. And then the fourth bucket is the bucket on the companies or the LLP, the requirements that you have, which are perhaps much more minimal than what you have in regard to the other 3 buckets that I spoke about. But those are nonetheless required. For example, under the Companies Act, your letterhead requires you to place your registered office. So small compliances, but each of these are important. And if you go through all of the compliances, this would also help you run your business a whole lot more smoothly, even if you didn't have an investor. And from an investor's point of view, it just makes the investor so much more comfortable. And the last compliance, which I can't stress enough, is from December 2013. It's now absolutely imperative for you to have a sexual harassment policy in place.
Okay. So, Payal, correct me if I'm wrong. I think my belief has always been that with compliances and everything in place, having the proper registration, having all the IPs in place, I think startups and entrepreneurs are more disciplined in their approach, and that at the first level regulates their own procedure of working, and then translates that into an investor confidence going forward.
Absolutely.
Great. So I'll pick up the next one. Yeah, this is something, accountability compliance. So very rightly, like you took the Uber example in the last slide. Now, how could, so that let me, okay, so how could they avoid this? By making sure that, what security measures could they have in place? Is there some agreements, or can they insure themselves against such events? Is there something that they can do around this? Because from my perspective, I could have suggested a startup to think about these events initially, and so this is a kind of a risk assessment that they have to do in the starting, and then they have to find out how they need to mitigate that risk. So for that, if they have to take any security measures, if there's any safety audits, do you have some thoughts on that? If you can suggest something on this one.
See, Anurag, and from experience, I can tell you this. And the first thing that startups, both from a personal as well as from as being a lawyer, having seen startups very close up, one of the big challenges a startup has is, and this is the reticence on their part on compliances, because the question really arises, where do I put my resources at the outset? And this is my advice to a lot of startups, that join hands with an accelerator at the outset, because this helps bring in a whole lot of knowledge to you without having to reinvent the wheel.
Okay.
So there is a whole lot of knowledge that is sitting with people who are in the accelerator space, be it from various aspects of running a business, including from the legal compliance setup, because that work has already been done. 80% of that work is already done. Qua 3 buckets, which are your companies or an LLP, whether it's your labor legislations or your environmental legislations. So all that is required is a run-through list and saying, have you ticked all of these 37 odd boxes in terms of the licenses and the requirements of their licenses. The last bucket is really where some amount of specialization, and perhaps that will need to be reinvented given the type of business and the space you're in. Like I said, if you're in the insecticides or the drug space, then given that particular drug that you're getting into, whether it's generic, are you looking at the patent of it, and in the intellectual property space, those 2 areas will perhaps require some amount of reinventing the wheel. But 80% of that compliance can already be done there because that knowledge is sitting in some place. So that's my first bit. The second bit that they do, need to pay a great amount of attention to is on the contracting piece with whether it's with your vendors, with your employees, or different. If I can just request you to, I'm sorry, I've kind of jumped one slide because I want to come back to that later. Anurag, if you could just jump right to the last slide.
This one?
Yeah, this one. Thank you. Because, from an investor point of view, apart from compliances, I'd also like to see, are all the contracts that you're in currently, are those in place?
Yeah.
And are the various aspects of it
So
which
in
need
fact,
to be closed in? Sorry, go ahead.
sorry, I think, very rightly said. I could actually connect, how we could secure this kind of a situation. If our vendor agreements are in place with the right clauses, I think that would really help us enforce the right kind of, procedures employed by our vendors or by the community to make sure that our risk is protected, our interest is protected, and the risk does not eventuate into a loss.
Yeah, because one of the things that's very important for an investee to understand is that when an investor is coming in, each of these, even your contracts between your employees, vendors, these are all seen as an asset, a movable asset, which they're going to be, this is something that they're going to either inherit, or even if they're coming in as a minority shareholder, they're going to have to live with. So it's very important that these aspects are looked into by the startups right up in the beginning. And some of the aspects which are in that slide, which I think they can see, is that the service they're in or the product has to be very carefully drafted in the contract. After all, what is the service I'm providing, or what is the product that we're selling? And if there is a breach on part of either side, how is that breach to be rectified? How are payments to be derived? How are because from an investor point of view, you don't want to be laden with a lot of debt. You don't want a whole lot of receivable on your books. You actually want to see that money.
Yeah.
If a contract's not going well, how easy is it for that startup to be able to terminate? What happens if you terminate? What are the consequences of that termination? Another very important perspective from the point of view of an investor, which a lot of startups may not think about, is really jurisdictional aspects. And I can tell you this, having advised investors, they think very closely about these aspects. So, for instance, jurisdiction, if I'm in, foreign-based investor, where is the jurisdiction going to lie? Do I have to come all the way to India to litigate? Would I rather litigate within my own jurisdiction? Or would I prefer to have an arbitration clause? Also, a careful amount of thought needs to go into drafting of arbitration agreements, because the venue of arbitration can decide the jurisdiction in which country where that award will be enforced, or even an injunction can be sought. The number of arbitrators, because if there are 3 arbitrators, the cost of that arbitration goes up significantly, because you're not only now paying for lawyers, but you're also paying for arbitrator fees at every sitting.
Right.
So in a nutshell, it's very important to think through contracts that you're drafting at the outset, if you're looking at it from an investor's point of view.
Right. In fact, one more suggestion comes in, as since my past has been of an entrepreneur. What is very important is that, as entrepreneurs, we get very excited because we're very emotionally connected to our startups. One gets excited with any contract that comes in. All they care about is that they're getting the contract, they're getting the orders. But in the hindsight, they actually forget to reading all the clauses very carefully before signing the dotted line. Whether it's a vendor contract, whether it's a client contract, be very, very careful with all the clauses, because when the legal hits bad, it hits really bad. So that's where I think all these aspects need to be thought about initially, as well as from every time to time whenever you're signing any contract. So any dotted line, make sure that you read it well, vet it well, evaluate, get a opinion, and I think that is what really matters in terms of protection of your interest. So thanks, Payal. In fact, just one more challenge that I wanted to understand was that when startups have the founding team and the kind of shareholding that they have within their founding team, and then when there is a family and friends round, what are the kind of clauses in the SHA, and what kind of exits can they look at? That's where I think a lot of startups have also asked us questions several times. I mean, it'll be best if you can throw some light on this one.
Anurag, I'll tell you one thing from a lawyer's perspective, and I know that with due respect to all startups and everybody else, but as a lawyer, I have to point, for me, when I look at a contract, I'm not differentiating between family, friends, or an external investor, third-party investor, because
Right.
ultimately, startups have to remember why people put money into a company. Ultimately, it's about the return on investment. Whether that
Absolutely.
return on investment from a family's point of view may be to see your friend or family member do well, or whether it's hardcore return on investment on my money. Never lose sight of that. An investor comes in because he wants a return on investment.
Yeah.
And therefore, they're going to tie in the startup on very hard targets, which are top line, bottom line, and market share.
Right.
It really is. It boils down to it being so simplistic, and they're all looking at the three modes of exit. So if your business is extremely successful, they want to take you to an IPO, because that's really where they're going to derive their highest investment. If they're not able to get through to an IPO stage, they want to do a strategic sale. And thirdly, they might look at a minimum guarantee. So there's no way around it. So if you are a startup looking to get money, these are key factors that you have to keep in mind. And a contract has to be drafted in a manner that provides this return on investment. And I keep saying this to startups: do not overpitch it. Because if you want money, they've got to come in on targets that are actually, honestly, realistically deliverable. We saw that in 2008 when investors were not able to get the ROI they were looking at, and what that did to both investors and investees, because then you're getting into litigations. It's a huge waste of management time and detracts away from the final goals. So those, while they're getting into contracts, it has to be realistic on both sides. And also, careful attention has to be paid to reserve matters, particularly where investors are coming in on a minority stake because they're going to protect themselves. Because ultimately, it's about protecting money in a company that they don't have management control over.
True. Great. So I think, Payal, we've covered most of what from the investor side, the kind of questions that I have faced and the problems that I have faced. And thanks for coming up with
Anurag and Payal, are you finished?
Yes, from my
Yes,
end.
Radhika, we are.
Okay, I'm sorry, I lost you
Questions.
people in between for a couple of seconds, so that's why I just went mute for this thing. Apologies to everyone for that. So we'll take up the Q&A now, and if you have any questions, can you please raise your hands? There is a small icon on your screen, for all the attendees. There is a small icon on your screen with a hand. If you just click on it, I'll be able to know. Okay, so while that is happening, we have piled two questions from Abhishek Wesh. His first question is, can a startup shift from LLP to private limited if required? Is the conversion process smooth, assuming the LLP has trademarks, various tax registrations, bank accounts, etc.? Over to you, Payal.
Yes, an LLP can move to a company, but there are compliances that will be required. That, I mean, I can take that offline, but to answer your question, an LLP can move to a company. It's possible.
Thank you, Payal. From Abhishek, we have another question. That is, suppose a startup is a proprietorship or a partnership firm, and the potential investor needs it to be a private limited or LLP as a prerequisite before making any investment. So he just wanted to know at what stage can the startup go in for that conversion. Most of the times, the investor gives 9 non-binding term sheets, and they back out anytime with or without giving any reason. Over to you, Payal.
Yeah, so Abhishek, the first thing that you need to understand is that a proprietorship is a one-man show. Okay, it's by its very nature, it's not distinct from the individual. It's not a separate legal entity in which money can come in through somebody else. So even if somebody wanted to invest in a proprietorship, that's not possible. So you will have to structure yourself as an LLP or a company. There's just no way out of that. So does that answer your question? If not, let me know and then I can help.
I'll just sorry,
What I wanted
Apal.
to know was, okay, sorry, Ritika. What Abhishek also wanted to know was on the term sheet aspect that these are non-binding,
Yes.
which is true. So can I answer this question? I think it's a two-step answer. Firstly, there is no such thing in my eyes which is a non-binding contract. And even an oral contract is a contract in law. However, in a term sheet, what happens is no consideration passes hands, which is why it makes it non-binding. So it's a friendly commitment to say, look, if you do X, Y, or Z, I will be willing to invest. But one will have to look at a very term sheet very carefully with screening eyes to see that if that XYZ was done, would it make the term sheet binding or not? So, I mean, I know this is not perhaps the answer Abhishek is looking for, but if he still wants more clarity, tell him to ask.
So, Abhishek, if you're still there, I'm just going to unmute you and you can ask your question directly. Yes, Abhishek. Abhishek, you can speak into your microphone. Abhishek, can you hear us? Okay, in the meantime, I guess Abhishek would like to put his question on the chat. In the meantime, Payal, we have one more question from Kavarpreet Singh. And his question is that before funding stage, should we go in for or hire a legal expert? What if we can't afford that cost? Also advise us for regulatory compliances for mobile app space with all the recent noise and gray area covering this sector. Over to you, Payal.
Okay, so as a lawyer, our training is to think of the worst, and I'll always advise people to get external legal help. It's always important. Yes, there is a cost attached to it, so you will have to find the money, whether you do it initially and then recover it back from your investor. And this is not, I'm not just telling you this because it's a marketing pitch for lawyers, but it's just an important aspect of the business that you need to build in that cost. And on the second part of the question, I think Kamal will need to be a little bit more specific because that's just too broad for me to answer. he needs to ask me what is it that he wants, what does he want to know on the mobile app space.
Okay, so I'm going to be unmuting you, Kamalpreet. If you're still there, I'll just unmute you. You can ask your question directly to Payal. Yes, Kamalpreet.
Yeah, hi. You can hear me. Okay. Basically, I don't know if we know what we want to know, then we won't, probably hire a legal expert. So the thing is that we don't know what will come in, right? And for that we'll need advice from people like you on what things, if we are launching a mobile app. So what things we probably have to safeguard on. So that is the question.
Okay, that's quite well put, because as a lawyer, I wouldn't know anything about the mobile app space, which is true. So I see what your question is. So let me try and answer this for you, Kamalpreet, in the best way that I can. Now, see, in a mobile app, I'm assuming that you would have written a software, and correct me where I'm going wrong, okay? Would you have written a software? And would you have created some sort of a software drawing around that?
It's a service-based app basically.
No, I
We are
understand,
working
but
on
when you make the app,
yeah.
or did you make the app, or did a third party make the app?
No, it's a in-house team only.
So your in-house team made the app, right?
Right,
So
right.
there would be some intellectual property in the creation of this app.
Okay.
Okay. Now, when you made the app, you must have done some software writing part on it.
Right.
There must have been a software drawing around it as well.
Right.
So that software drawing, I'm guessing, would be copyright protectable. Okay? And it's an easy process, because that copyright drawing can be, you can go to the copyright office and get that protected. You can file for that protection. What that copyright protection will do is to create a connection between the author of the copyright and the owner, the person who wrote it, and the copyright. So while a registration is not compulsory, it would be something that is good to do, not very expensive, and the process doesn't take too long. Okay, so that's one thing. Secondly, also the written material on that on your mobile app would be something that would be copyright protectable.
Okay.
Now, tell me, Kamalpreet, are you okay? So now the second part is, how do you protect this copyright? So every time you're getting into a vendor contract, your contract must provide for the fact that you're the owner in this copyright, and in every aspect of this mobile app. So whether it's the trademark, I don't know what you call your mobile app, whatever you call it. Let's take an example of, I don't know what mobile apps, like maybe suppose Twitter was an app. So Twitter, or that the name Twitter would be trademark protectable. The logo that you have around your mobile app, you know, the little drawing that you do, that would be trademark protectable. And both trademarks and copyrights are not very difficult to protect. They are not very expensive to protect either. So this is something which is good to do. You also want to do non-disclosure agreements with people that you're talking to, even in terms of your investors or vendors who you're having a conversation with, which is, you know, which is confidentiality based. So you want to get into those. And all of the other things that we've already spoken about in this presentation. So I hope that helps from a very generalistic, broad point of view.
Yes,
But if you
I
have
probably can take it offline, because then I'll have to be specific about my idea.
Yes.
Right.
Okay, thank you, Kamalpreet. We have another question from Samarjeet, sorry, I'm sorry, I misspelled your name. An LLP with two partners, sorry, I'll just, one second. Okay, LLP with two partners, and the problem is the other buddy is going for another startup, and I'm a technical guy, and I've given 2 years for product. Now, can I proceed without him for launch and further future processes? And is there any way to solve it out apart from mutual understanding? That's a question from Samarjit. Over to you, Payal.
Okay, I think you need to put Samarjit on the line. I need to understand this
Sure,
query a
sure.
little bit.
Samarjit, I'm going to be unmuting you. You can ask your question directly. Yes, Samarjit?
Yeah, hi Payal. And
Thank you.
the question is very straightforward that one of my partner, we have started 2 years ago, and now he is going to put up another startup. Uh, so whatever we have prepared in the field of augmented reality, I want to pitch it in market, and an investor is already ready. So can I do it with the same firm from which we are operating till now?
Yes, why not? As long as you're willing to share the profit with him in the manner that you. So I'm assuming it's a 50-50 partnership, right?
60-40 partnership.
So in the same proportion, as long as you're willing to share the profit with him. Where is the issue? So the issue is where is there a non-compete between the two of you on the other startup, and is he doing the same sort of thing in that startup which you don't like, or is he not giving time? So what is the issue exactly?
Actually, he's not putting time and effort for the same thing.
Okay, so
So can I bound him, or can I is there any restriction I can put for him, or what can be done in that kind of scenario?
okay. So question 1 is, can you put a restriction on him? Check your LLP agreement. What does it say about non-compete? And what does it say in terms of time and effort and him going to another startup? I'm assuming the fact that you're questioning me on this, your LLP agreement is silent on it. Correct me if I'm wrong.
Yeah.
Okay. Now, I'm going to give you some very practical come legal advice, Samarjit. Okay? So hear me carefully. Now, do you want to spend your time fighting, or do you want to spend your time building your business? So think it through before you answer.
Okay. Or maybe I'm comfortable with business, not with fighting.
With business, right? So my recommendation would be to first try and get him to do an amicable split. So one of the ways that you could do it is to get him to sell his stake to you.
Okay.
And you reconstitute the LLP, bring in somebody else. Or then the other way to do it is, if you're not willing to fight with him at this stage, is to seek some hardcore legal advice and see if you all can take the business out of that LLP.
Okay.
So you will need to, strategically think through what are the long-term goals and how you can best exit this. Otherwise, your last case scenario is to live with building the business and giving him the percentage of the profit that he's entitled to.
Okay. So if I take that product from LLP, then the same thing I will be doing, that putting this startup dormant and doing another startup, right?
Assuming your LLP agreement allows for that, yes.
Okay.
So look at your LLP agreement very closely, what you can do in terms of a non-compete.
Okay. Thank you.
Okay.
Thank you, Samarjit. This brings us to the end of the webinar. I see no more hands raised and I see no more questions. So requesting you all that in case you have more questions, please feel free to get in touch with us. Our mail IDs are already with you. And thank you so much for being a part of this webinar. And I hope you found it useful. And we look forward to you joining us for our next webinar as well. We shall keep you posted on that. Thank you so much, Payal and Anurag, for your precious time. Thank you so much once again.
Thanks, Ritika. Thanks to Payal and the Just Contractors team.
Thank you so much.